Monroe Bell versus Ameristar Casinos, East Chicago, LLC, 45 CO 11007 CT 137. And Mr. Who's here on behalf of for the record?
Good morning, Your Honor. Trent McCain on behalf of the plaintiff, Monroe Bell.
Okay.
And Paul Johnson on behalf of the defendant, Ameristar Casino, East Chicago, LLC.
Okay. What are we here for? Pre-trial? Final pre-trial? Or?
Yes, Your Honor, trial management. A couple of things have come up. Number one, Your Honor, the plaintiff has filed for bankruptcy, Chapter 13 bankruptcy, but he filed in Illinois. And I learned recently that Illinois is unlike Indiana, so it's not necessary to have an application to employ. I'm still able to represent Mr. Bell without interruption. I just have to notify the debtor's attorney and send them any settlement statement that may result from this case. And I've spoken with Mr. Johnson regarding Ameristar's position, and I'll allow him to elaborate on that.
Judge, I'm here in place of Chuck Hoppy, who has been in the hospital for the last 2 weeks.
Okay.
And we're asking, there's a trial date November 25th, and we're asking the court if we can get a 60-day continuance on the trial date. It looks like Chuck's going to be in the hospital for probably another week. He's dealing with a leg infection that the doctors haven't quite figured out yet. And so from our standpoint, we thought we were coming here with the bankruptcy issue not being figured out. On top of that, with Chuck's condition, we were going to be asking the court to continue that trial date of November 25th anyways.
I have no objection.
No objection. We'll go ahead and continue it. And Nikki, how many days were we going to be? How many day trial?
I think we were thinking, 60 days, right?
Sure. Are you talking about the trial?
Yeah, how many days?
You know, I think it was scheduled to be...
I got it for 3 days. Oh. Okay, get my calendar off the...
For when? This year or next year?
Next year.
2014.
Yeah.
So do we want to reschedule the trial management too?
Sure.
Yeah.
We could do that. problem with it. I don't know which ones are gonna go and not go. So, gentlemen, I think what we're going to have to do is, I have my trial calendar here. I don't know offhand. Some of these may have already settled, and some of them may have not. And some of these dates may be open. You both want to try to call the court, my court administrators won't be here till after 10:30. So maybe if you two could coordinate, call the court, and we'll try to coordinate a date when she's here. And she'll know what's off. And
Do you want to set a date today for us to come back for a final pretrial conference, or?
why don't you do all that
Okay.
so when we know the trial date?
Perfect.
Okay?
Very well.
And she can set up for that also. All right, gentlemen?
Thank you.
All right,
very much.
thank you. All right, what's the next matter? Roads? You here on roads? Okay. Dorothy Rose, first 45 CO1, 1009, the estate of Dorothy Rose, TR, or trust, TR9. Let's see, we got an appellate opinion here.
Yes, Your Honor.
Let me see. What was the finding?
Well, essentially what had happened is the trial court at a hearing had granted a summary judgment in favor of the estate or the personal representative of the trust, which disposed basically of everything. The Court of Appeals reversed and remanded it, so we're back here
Oh, okay.
on the will contest, the trust contest, and all of the matters. And we need to get this back on the calendar for trial, do some discovery, and there's an issue, if I'm not mistaken, I received a correspondence from Attorney Wilk indicating that there was about $250,000.
100, well, I got 103,000 I'm holding in my trust account. And then they have the rest, I guess, in various accounts, according to my, how I said it, in my letter to you.
Yes. There's some funds that, we'd like a restraining order prohibiting the disposition of any and all other assets that remain. I think Jackson National Life has some. Mr. Wilk has some in his trust account until we get this case disposed of.
What was the contested issue here?
Competency of the decedent.
Undue influence, mental competency, and fraud.
Okay. All right. So we need so you need to conduct some more discovery?
Yes, we had commenced it. We've taken the deposition of one of the personal representative trustees. We have not taken the other depositions. There has been some paper discovery exchange, but we need to conclude the discovery. There's about 3 or 4 more depositions.
How much time do you need for discovery?
Say 120 days.
Well, with the holidays coming up, probably that's optimistic.
Yeah, leave it out here. Okay.
We might need a little bit more since Christmas and Thanksgiving and all that are coming up. Yeah, probably more than 120 days in light of the fact that, the holidays are on the doorstep.
Want to go into May?
For a trial date? Or what? Oh, discovery? Yeah, let's do discovery until May.
How about April 15th, discovery cutoff? Is that enough time?
Yes.
Okay,
Is it?
yeah. That sounds good, thank you, yeah.
Okay. And then, set up for another pre-trial. May 23rd?
Certainly.
At what time?
11.
11?
11 o'clock.
Yeah.
Any slots any earlier or not? No?
Let me go. You rather do it on a Monday? 'Cause I have something set at 9 that day, which one come in the afternoon. We can do it on the 26th at 9:30.
That work for you? Yeah.
Either date's fine.
Let's go with the 26th so we can get the next morning.
9:30. Okay.
Excuse me, Your Honor.
Yes.
Got a question for us there?
Well, I'm sorry. I thought Mr. Neff was representing.
No, I'm representing myself.
I have for the record, what was your name again, sir?
John Kinski,
Okay.
mistake.
And?
My appearance before.
Right, and I remember.
Yes. I filed petitions, motions. And I just resent another set of motions in, which are all compelling to the same motions that I sent in previous.
And what, you want to refresh my memory as to what they were, sir?
The last motion I sent in was a motion for the will. We could skip that one for now. The other motions are a motion to compel.
What are you asking to have them compel?
To compel for the accounting. There was a $95,000 proceed of sales of homes that were paid for in cash.
Did we ever address those issues?
No, there was a stay of proceedings, so we put that on.
Yeah, okay, there was,
But
because of the appeal?
actually, all these issues and all this is going to all merge into this same case now that we're back on, from the appeal, because one of the issues is what it is, and I think Mr. Neff's going to cover all of that.
So you'll get copies of everything.
Well, Your Honor, essentially, if I may, Director Court, I don't mean to cut you off, John.
Sorry.
Essentially, where we're at is, because the Court of Appeals reversed and remanded back here, we need to get back on the trial. At the time, before the summary judgment was granted, there were restraining orders prohibiting distribution of assets and that sort of thing
Right.
in place. We'd ask that those be reinstituted for whatever's left, because there has been some distributions.
All right.
And Mr. Wilk is new to the case with respect to, he took over for Mr. Skozin. After the summary judgment and the distributions, Mr. Wilk took over, so we need to sit down and get together with respect to what assets are left, what was distributed, and do a proper accounting. And I'd like to have, some time to do that. If you want to give us a deadline of 30 days to do that, I think that would be wise.
I think I'm up for that, yeah.
So 30 days to do the accounting.
We did an accounting, but I guess what we got to do is, I think there's discrepancies amongst the parties about some assets, so if we can target and coherently talk about
What's there,
what's there, what's not, so that I can understand, then I think we can solve all that.
Well, I have an understanding that the accounting has been filed and completed. This is not an accounting, this is a basic, it's
inventory,
it's a
like
statement, inventory. It's
inventory.
not accounting.
Well, that's, I guess that's what you're talking about.
Yeah, but between Attorney Neff and I'm sure we can reach an agreed,
Well, between Attorney Neff and I, and
yeah,
because I will have the accounting also, statement with billing receipts, check receipts.
Well, accounting would be filed, has to be filed to close the estate. I mean, before, to disperse, you have to do an accounting.
Yeah, there's also disbursements of $450 that was written on an IRS check, which was for Joseph, which is already taken out, and then retaken out again, so the accounting is not an accounting.
Well, I mean, those are things you have to do the accounting, and then you look at that, and then if you object to the accounting, you file an objection, and then we have a hearing, and you tell us what you're objecting to.
So if they
But
said-
before you can do any of that, the estate has to go forward. You have to do your inventory, and you have to do your accounting, and all of that.
Then it comes to another conclusion of the problem. There was 69,000, there was supposed to be 77,000 held within the account, along with 103,000 that Mr. Lewis is holding now.
Okay,
38,000 is in Jackson, which is approximately 44 with interest now.
okay,
That's being held by Jackson.
okay.
Somehow it slips through, because I don't trust
What
Mr. Monty
slips
Joseph
through?
Trezani with the monies.
Who's this?
that's my clients, the trustees of the trust.
But you have the money in your account?
I have 103,000 and they've got the other assets, but I think according to Mr. Neff's motion, the court has entered an order stating everything, so I'll impart that information to my clients and
I mean, if they do anything with the money, they can technically put them in jail. I mean, they have a
Yes.
fiduciary relationship.
Right.
They can't
To
just
produce
take
the funds that are supposed to be there.
Right, yeah, I mean, if they can't produce them, they got a real problem.
And that would go along with the accounting. Like as of today, there's 40,000, and as of next week, there's 25. That's what we want to stop. You know what I mean? For Mr. Joseph Trezani, just to be able to go in and dip in.
Well, that's exactly what we are. That's where I just stopped. I mean,
Accounting as of this day, this minute.
if
this hour.
he does something like that, he's doing it at his own peril. That's for sure. He's got a real problem. And I would certainly not hesitate to sanction him pretty severely if he did do something.
And the originality of the last will actually was that I was looking for a third, and if the civil court can compel that if they do something like that, that there can be criminal charges pressed against them of taking of monies.
Not
Correct.
criminal, civil,
I
a
believe.
lot of things could happen to him.
Okay, so I just want to make that clear, then that the monies being held be released in a proper manner.
What are they doing with this money, Mr. Wolf?
it's all in accounts.
It's all in accounts? Okay.
Well, the only concern that I have, Your Honor, at the time that she passed the...
Who is that?
That's Robert Kitchens. That's my client. But at the time that she passed, there was about 400,000. There was Indiana inheritance tax was still in place at that time. There have been some consents to transfers that have been approved. And I just want, whether it's themselves or Jackson National Life or Western and Southern or any of these other investment vehicles, that those companies be instructed as well, those funds are not to be released to anybody.
Money being held is seized.
And what I would like, as far as to, I think, Mr. Wolf and I discussed this, and
Why don't you prepare an order saying any dissipation of those, any cashing those assets out, or any control over those assets until we resolve the matter.
Also, I'm stating here that it was $77,000 on March 22nd date to be held at that specific time. Mr. Slozen walked out, he don't know where they're at.
Well,
The money was a cash sale of the home that Joseph is holding in an account.
I see what you're saying, but I think these are matters that are going to be all clear when the inventory and the accounting, and then
And
I mean,
again,
do you know exactly what's there, then you really can't
right,
object till you see it. This is what's there today.
we're all clear on that.
Okay, well, when you find that out, then if it's not there, then come back into court,
At that
we'll
time-
address it. And when we know exactly what's there and what's not there.
So at that time, it was stated 77, it dwindled down to 40 plus 29 is 69 then, and now it's 40 minus whatever else is supposedly 25 now. And who knows if the 25's there, that's what I'm getting to.
Well, that's what we have to determine, that's why we're all here, am I right?
Right.
correct.
Your client has something to say.
You can't trust it. And may I ask a question within the court?
Sure.
There's also two other statements. There's a writing stating that my sister Sheila Kaczynski, which is on Mr. F. He can address that. That there's $5,000 for mental health only. That the address is, well, he'll give that to her, to whomever facility she went to. There's an address of the mental health for my sister and the $5,000 mental health for myself. I'm putting a motion to comply with the will, which is separate from trust, for $5,000. $5,000 will be released by Mr. Wilkes or Joseph Staten to me. In my compliances, I wrote, I, John A. Kaczynski, complied with the will as stated. I've sought out mental and medical help since July 15th. I've completed an inpatient program at Eagles Memorial Hospital and afterwards completed an outpatient program at Pace Community Hospital and will be ongoing continuing follow-up with them. As stated in the will, asking the $5,000 for mental health to be released to John A. Kaczynski. It's a motion that I filed. We can address that today.
I don't think so, because see, all of that money is in the will and the trust, and that's all, you know, if Mr. Neff wants the assets frozen and do an accounting, I don't think we can do a piecemeal disbursement, so I think we have to.
Let me just say this, probably if you're entitled to the $5,000, you will get it.
My client has informed me that there was some money held in the proceeds from the sale of a house. There was, as we spoke, about $29,000. Recently, they just took out another $4 in the last few weeks for trustees' fees, and that's what we need to stop.
We need to stop all that, not prepare an order.
I'll submit a
Put that in
agreed order with Mr.
Agreed
Will
order
within 10 days,
in 10 days.
and that order is effective today, correct?
Yes.
Also, as far as trustees go, fiduciary duties and so on and so forth, that Mr. Meister is a felon and cannot be trusted. It's that.
This is a pre-trial conference. Okay. It's a scheduling conference. Judge isn't here to hear evidence.
Thanks for clarifying that. I just wanted to be
I
clear.
mean, we'll get to all that once the discovery is completed and we're ready.
I just
for it.
want to make myself heard and clear today, Your Honor, that's all.
Well, you have.
And address things that need to be addressed also on my behalf.
Yeah, you'll be able, once you see what's there, then you can address these issues
Right.
and know exactly where your objections are and where you agree.
Okay.
You can iron everything out. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Have a nice day, Mr. Moore.
Thank you, Mr. Wolf.
Okay.
order, so looks like they have something on. Yes.
Morning.
For what?
Thomas Merrill, the Salt Lake, Indiana LLC.
Yes, he is here. And who are you?
Attorney Mike Anderson on behalf of Salt Lake, Indiana LLC.
Okay. Anybody coming on the other side?
I spoke to Attorney Buscemi. He told me he would be here.
All right.
Okay.
You're on appeal?
Gonzalez
That's not till later. You got two people in front.
Okay.
We got you in here. You want to wait a few minutes? We'll wait on Buscemi and see if he shows up.
Say 25th.
Everybody's here on that.
Today's 25th.
Today's the 25th, yes.
Okay, I got your appearance and your additional time to plead. Is that what you were here on?
Yes, Your Honor.
South Lake, Indiana?
I've spoken to Mr. Buscemi, and we've come to an agreement that this hearing would be continued until November 18, 2013. When he arrives, he should be able to confirm that.
What's the cause number on that?
90, PL 90, 1309.
90? Okay, so the rest of it, you got a motion to dismiss on that.
Or you got two cases, there's two? WEA South Lake LLC?
That's my knowledge, Your Honor.
This one is
We got 89.
South Lake, Indiana?
That's
LLC?
my, yes, correct.
And there's another one, 91, certified CO 1309 PL 91. You in on this one?
No, Your Honor.
You have no objection to this one?
I don't honestly know anything about
All
it.
right, let's wait for Mr. Buscemi. Clear it up. What time were they supposed to be?
All of them started about 10 or about 5 minutes.
Let's wait for them. Okay. Let me take this case while we're waiting for Mr.
I thought you were in the middle of something. Bring them in?
Yeah, bring him in.
This morning.
Go off the video.
Video.
All right, Jennifer McDermott versus Thomas McDermott, Senior, 45 CO1 1007 DR 670. Morning.
Morning, Your Honor.
Appears pro se. All right, we got all the issues straightened out except for the fees.
Mr. McDermott, since the last time we were here, paid everything except the amount that ran up to $500 a week. He hadn't paid the total of that, which was liquidated because it stopped last time we were here because he paid on time. So the amount he owes for that is $18,500 plus the fees. And I've got a supplemental request for fees to bring those up to date that I'd like to present. I talked with Mr. McDermott in the hallway, and the 2 times we've been here before, his position was, I'm not going to pay it. I'm not going to pay it. And then he told me again today that that's his position. He will not pay these amounts.
Hi, Your Honor. Basically, my position is that obviously every time I've been notified that Jennifer had a bill, I paid it. I paid Mike back, my attorney, more than an adequate amount to cover all those credit card bills. I was unaware, in fact, I lost probably $18,000 to $20,000 in his trust account because of untidy bookkeeping, and he had told me that the American Express bills were taken care of except for one. I took care of that, obviously. I wasn't notified till May or June of this year that there was anything due and payable, and once I was told that they were due and payable, I paid them. And therefore, I'm being penalized again. I lost $18,000 to $20,000 on the death of Mike, and probably paid Jennifer in excess of over $200,000 in various bills and other matters. So
What was that $500 a month for?
Under the terms of the original decree, Your Honor, Mr. McDermott had certain financial obligations that he had to satisfy, and the agreement was that he would pay her $500 per week until he had satisfied all those financial obligations, which he finally did the week of September 18, 2013. He stopped paying her, however, the $500 a week in December. So we've always, every time we've been here, it's, well, we still have that $500 a week. And last time we were here, you said, pay the rest of those obligations, which were some IRS back payment that he owed to her and some insurance premiums he owed her, to stop the $500 a week, stop the bleeding. He did that week. But, you know, his representation that he pays everything when he's asked, if that's true, we wouldn't be here the third time on these same proceedings. It's like pulling teeth to get these things paid. But now we're down to the last two that he has said consistently, I'm not paying.
yeah, and I never argued that. The first divorce took $5,000 in attorney fees. I'm not arguing over the attorney fees. I understand Mr. Angela's attorney fees come in, but basically, as I stated previously, that as far as I knew, I wasn't notified that I owed any bills until May or June of this year, and then I went ahead and fulfilled that obligation. Mike Beck, unfortunately, had all the records in his trust account. All my money that I'd given him to take care of the obligations disappeared, as well as the records, and to hold me responsible for paying those. As far as I knew, January 1st of this year, I paid her $110,000 in cash, take care of everything, and I thought everything was done and over with until I was notified by Mr. Angel, and I think it was June of this year that I owed the American Express bill, which I cleared up immediately, and the taxes.
That's contrary to the evidence we've already presented to this court. He told her in January, I'm not paying you that $500 a week.
Because
documented items from one of the TV companies, I think it was DirecTV, that he was under provisional order he's supposed to return. He didn't return until after these proceedings in the first court date started. Credit card obligations, I'm talking to Mr. Carpenter, who's his attorney, trying to help him with those things. I'm talking to him in January, February, March, April, before I even sent the letter. And Carpenter finally said, I can't get it done. Send him a letter and copy me with it. It's an evidence.
Mr. Carpenter was on my attorney on this matter. Mr. Angel and I was on the...
Did you get copies of the affidavits for attorney's fees?
Here's the supplemental one to bring it up to date. I haven't given this one. May I approach the court reporter to provide the updated one? There's the one that updates. Prior submission.
And did I understand that you said you don't object to some of these fees?
No, I haven't seen this, Your Honor, but I understand that she's hired an attorney, obviously.
Okay. All right. So essentially, your main area of contention is the $500 a week.
Your Honor, every time I was presented with a bill, I paid it. I paid her more than an adequate amount. I wanted to make sure her daughter was taken care of it after the divorce, and gave her $500 a week to take care of herself and her daughter, and basically I had no obligations to do such at the time.
Have you discussed Mr. Angel's fees with him at all?
I didn't bring my, honestly, I didn't bring my reading glasses, but I'll check the bottom.
I gave them the original one from when we were here in August. This just updates additional fees for the second and today's hearing and the work in between and following up on what's been paid, et cetera.
$13,000?
No.
That sheets.
That's the total she owes. She's told us work from the original divorce. The amount for this work since from January to date, including today's hearing, would be $6,100, none of which has been paid.
Your Honor, that's more than the total of the first divorce. The total divorce.
But you understand you do owe some fees.
Yeah, correct.
All right, so I guess all I need to do is make a ruling on the fees and the $500.
I don't think he disputes the $500.
Okay.
Because the last time we were here, we went through it. That's what the decree said, that's what he agreed to, and I don't think he disputes the math. I think since he doesn't want to voluntarily pay it, I guess if we just get it reduced the fees and the $18,500 reduce the judgment, I'll just have to collect on the judgment.
Or was the $500 based upon his compliance or not?
The $500 a week, the long story is, in February we were here, he settled it. And he was not going to be able to pay her the amount, the equalization amount. He said, maybe I can pay it in April. So we said, okay, fine. Until you can pay it, how's she going to get by? And under the provision of giving her $500, we said, fine, continue to pay the
The
$500.
lump sum settlement amount, he was paying $500 a week until he can give her the lump
Until he can
sum.
take care of that, and taxes, and all these other financial obligations.
When did he take care of the lump sum that he was?
Lump sum was first week of January of this year. And so
So because
And that's when he stopped paying the
he's got to pay $500 a week. How much was the tax bill?
well, there was the tax bill. The tax bill was like $7,800 to the IRS, $2,000 to her. There was a credit card judgment that he got satisfied in August after we started these proceedings.
When did he pay the tax bill?
The tax bill he paid after our first court appearance. The credit card he paid after our first court appearance here in contempt. The life insurance premiums that she was paying because he was not, he paid her that in September. He finally made the last payment to her for reimbursing her for income taxes she had paid in September, and that's when the $500-week accrual stopped. September 18th had been the last payment.
Your Honor, basically, again, every time I was submitted the bill, I paid the.
You were never submitted. You were telling me you never submitted these tax bills.
When that was the first time I seen it is when I got that. And then when I had my accountant check on what it was for, which I was unaware, I knew she owed it. But on $46,000 income, she only withheld $2,000 that year. And basically, any normal person would at least hold a minimum 15-20% of your wages. So I made up for all that money that she didn't withhold out of her wages. Then I paid what she allegedly paid, that $2,000, so I got stuck for that $2,000. It's just all this is greed. I continue to come to court and bend over, and it's just unfair, and that's why I'm not. I'll go to jail before I pay it.
All these things are itemized in the decree. You have to take care of this, you have to take care of that, have to take care of this, have to take care of that. And until they're all done, you pay her $500 a week.
Was these amounts set out in the decree?
Some of them were unliquidated and unknown at that point. Like how much the IRS, how much the credit card, we allowed Mr. Back and Mr. McDermott to try to negotiate the best deal they could. Cut down the amount of the credit card debt. If you pay him 6 instead of the 12, that's fine. Just cover any tax liability she'll suffer as a result of it, because the credit cards that they were living on were in her name.
Again, I paid those, and Mr. Back was given more than enough money to satisfy all the. I lost, again, Your Honor, I lost probably $18,000 to $20,000 with Mr. Back over the death.
Okay. All right, I will make a ruling on that. Maybe if you want to discuss with Mr. Angel your fees, you can come to some kind of an agreement, fine. If not, I'll
I would also like the opportunity, since we're here today, if the board has no objection, to examine Mr. McDermott in one of the conference rooms about sources of income and assets he might have that might be attachable. The petition is not for contempt, but proceeding
Why
supplemental.
don't I make a ruling first, and then you can do that.
I'm just trying to save, coming back to court to do it again.
Do you agree to that?
What's he want, Your Honor?
He wants to know what sources of income do you have?
Court has instructed me to wait, I'll wait.
I don't see where that's necessary. Every time I've been given a bill, I paid it. I'll continue to do that.
Let's see what we come up with.
I understand.
All right.
Thank you.
Thank you, Your Honor.
I'll make a ruling on this. If you can work out your fees, Mr. Angel, I'd suggest you do that.
Thank you, Your Honor.
And then you don't have to worry about what the court's going to do. Okay?
Thank you.
You're welcome.
Back to the next case. God, the wish of the next.
You guys ready? South Lake in town of Maryville.
Morning, Your Honor.
Town of Maryville versus South Lake LLC Delaware Limited Liability Company, 45C01, 1309, PL90, and same parties on 45C01, 1309, PL91. You enter, you need to...
No, he's not here on 91, Your Honor. There's no appearance on 91.
That's okay, just on 90?
Mr. Anderson has appeared on 90, and as he has represented to you earlier this morning, we have an agreement to reset this order to appear hearing for November 18, 2013 at 10 a.m., and I have an order resetting it to that date if I may approach the bench.
Yes.